For over 3 decades, biotechnology companies have claimed the right to own the discoveries made by their scientists about the inner workings of our bodies. But now a case before the U.S. Supreme Court is challenging the right of private companies to own patents on our genes. Daniel Ryntjes has been following the case and joins us live from Washington with the latest. Daniel?
Well, Mike, a group of scientists, doctors and patients have been leading a challenge to the right of private companies to own literally bits of our DNA. And the US Supreme Court justices have been hearing oral arguments in a case which could have huge implications on medical research and beyond. The question before America's Supreme Court sounds pretty simple. Who owns our DNA? For over 30 years, the US government has approved patents to the biotech pioneers, including a firm called Myriad Genetics. Civil liberties lawyer Chris Hansen is urging the court to reverse the practice.
We're a little shocked, frankly, that the Patent Office has been granting patents on a piece of the human body, and we came to court today to try and convince the court to prohibit the Patent Office from doing that.
Scientists at Myriad Genetics identified genes which demonstrate a higher risk of contracting breast and ovarian cancer. Breast cancer survivor Lisbeth Seriani says she joined the legal case because she was prevented from getting testing because of the company's monopoly.
I needed to have that testing so I could make medical decisions in order to keep myself healthy.
Lawyers fighting Myriad Genetics also say the patents inhibit other scientists from doing research in the same area.
Myriad doesn't have a patent on its test. Myriad uses the exact same test that geneticists all over this country use every single day. What Myriad says is you can use that test on every other gene in the body, you can't use that test on the genes we own. That's what's wrong here.
But Myriad Genetics says patent protections are necessary in order to justify the millions of dollars in research costs.
Without the incentive provided by patent protection, it's doubtful that these genes would have ever been created.
The Supreme Court is expected to rule in June. Perhaps the most important genetics case in history, it's also being closely watched by biotech firms such as agricultural seed producers and biofuel manufacturers. So the implications of a ruling on this case could have huge impacts on multiple industries and quite literally the very fiber of our being. Back to you, Mike.
Daniel Ryntjes live for us here in Washington. Thanks so much.